So today we're going to talk about the considerations when drafting a wraparound mortgage from the investor to the final home buyer, the consumer that is out there. Now, we're not going to talk about the compliance issues, but more of what documents do you need in regard to that wraparound mortgage, what should be contained in it, and how should it be drafted. So let's assume that as the investor, you've already bought the house. Now, you may have bought this home utilizing direct seller financing in which there is a note and a deed of trust that you gave back to the seller. Maybe you bought it with a wraparound mortgage, wrapping around the seller's first lien mortgage. Or maybe you bought the home subject to the seller's existing mortgage and possibly even given the seller back a second lien type mortgage on the property. Or heck, maybe you even borrowed third-party financing for some reason and put a second or a third lien on the property. And now you're ready to sell the property to your home buyer. So what does that look like? Well, in most states, it's going to be a note, a deed of trust, and a warranty deed with vendor's lien. And what's important is the note, which is, of course, your promissory note, the promise to pay. It needs to outline, of course, what your terms are between you and your back-end buyer. What's the loan amount, the interest rate, the monthly payment? Is it a 30-year term, 20-year term, 15-year term, etc.? In some places, in some environments, such as a rural or underserved arrangement, you might be able to have a balloon payment built into your transaction. But as part of that note, you're also going to describe in it what the underlying debt is so that people understand when they look at this that this is not the first lien mortgage, that it's actually a mortgage that wraps around either an existing first and or second lien mortgage that may exist on the property. Next, of course, is going to be your deed of trust, which is the security that the homeowner is going to give back to you. This is what secures the note with the property and creates the lien on the property. Again, when we draft these deeds of trust that wrap around the underlying debt, we're also going to describe within this instrument what those underlying debts are. We want to be clear so that when a future title company or mortgage company looks at this deeds of trust, they know exactly what it is, what position it's in, so they understand how to refinance or pay off the mortgage appropriately. And of course, finally, there's going to be the warranty deed. Now, the warranty deed is the document that the investor gives to the homeowner that states that they own the property. The note and deed of trust is the payment obligation from the homeowner borrower back to the investor. So in this warranty deed with vendor's lien, the vendor's lien typically means that there is a mortgage on the property from the home buyer back to the seller lender, which is, of course, the investor. Now, I want to point out it's important that when you draft these, don't be cheap. And guys, I'm sorry, I'm an investor, and as an investor, I'm cheap. I know other investors are just cheap. They always want to save a buck. Don't try to draft these yourself. Don't go on LegalZoom or some other document prep site and try to download it. Go to a knowledgeable real estate attorney in your venue, in your state, and let them put this transaction together for you properly. Now, in addition to just having it drafted properly so that you have a valid document between you and your buyer, which really protects you at the end of the game, you want to make certain that you have checked your specific state to ensure you're meeting any of the other rules and regulations that might be out there when you're selling a home to a home buyer as a wraparound. It's important to make sure you understand what the rules are in your state. Various states have various rules and regulations. I know that here in Texas, they're more strenuous than other states. So take time, speak with a knowledgeable real estate attorney and determine what the rules and regulations are in your state. So when you're structuring the transaction between you and your home buyer, remember that you're wrapping around the underlying lien. You want to make certain that your loan balance is at minimum equal to all the underlying debt on the property, whether it's the existing first lien, second, or even a third lien mortgage that might be out there. The last thing you want to do is get upside down with anybody. You want to make certain that you've allocated for things such as private mortgage insurance or MIP possibly. that may exist on the loan you took subject to, because you cannot charge your back-end buyer what you're not giving them. In other words, investors rarely provide mortgage insurance to their borrowers. And so since you're not providing that, you cannot charge it, even though you might be paying it in the underlying mortgage. So one last thing for consideration, and I get questions about this all the time, is can I do a double wrap, whatever that may look like? Because oftentimes as investors, we may buy a property subject to the existing debt. There may be a down payment assistance debt associated with the property. There may be loan modification debt. We'll call these HUD liens that may be out there. I have seen up to 3 modification liens on the property in addition to the down payment assistance mortgage as well as the first lien mortgage. And so when you're drafting your wraparound mortgage, your loan is going to wrap around all of those at one time. And what you've got to learn to do is to track your loan balances, because as you're paying down that first lien mortgage, so often you're not making payments on those second, third, fourth liens at all. These HUD liens often have 0 interest and 0 payments. And so the last thing you want to do is get your wraparound mortgage upside down with your first lien mortgage and the total debt of what you owe to the lenders or the seller when you bought this property. So make certain your funds are allocated properly and don't get caught upside down between your home buyer and what your obligations are between you and your seller. And so as you structure your wraparound mortgage, remember it's always best to incorporate that third-party loan servicer who will collect the payment from the home buyer. They will pay your first lien, second lien obligations between you and your seller next, and whatever is left over will then come to you. Of course, this is our fraud protector for our industry. If you're looking for a good loan servicer for your owner finance transaction, take a moment and reach out to us at OFN Loan Servicing. You can find us at theownerfinancenetwork.com. Another consideration is do you want to put a due on sale clause in the mortgage between you and your back-end home buyer? Now, in most cases, that answer is yes, which allows you the same control that mortgage companies want to have with their due on sale clauses to their borrowers. So in most instances, we like to include the due on sale clause in the mortgage. And there are other various provisions that you can put into your wraparound mortgage with your home buyer that may cover you on certain things, such as what do you do in the event of a default? Do you want to specify some fees for inspections and things of this nature and actually spell those out or not? Or leave them a little bit open in the air, because rarely do investors describe what those fees might be, and rarely does a deed of trust explain those items. And so since there aren't any particular lending documents that may lay out these issues, such as inspection fees, other attorney's fees, etc., that may occur in the event of a default, it might be wise to consider incorporating those into your transaction in some format. Now remember, you're the lender and you dictate what those fees are between you and your borrower. You'd want to disclose those possibly in your contract. And if you do so, you want to relay those to the closing entity so that they know how to properly prepare that wraparound mortgage for you. Now, once that's done, you also want to know what your foreclosure laws are in your state. Most deeds of trust stipulate that the foreclosure rules are governed by the property code then in effect in the state in which you're located. There are some that have 20-day notices. There are some that may have 30-day notices. There are some that might have more. Read your documents, know what the rules and regulations are for your state so you can include the proper language in your wraparound mortgage so that if necessity dictates that you have to start foreclosure, you can do so in the minimum time possible. For instance, here in Texas, for an owner-occupant, we have to send out a minimum of a 20-day notice to cure. However, some deeds of trust, mostly those that are typical national Fannie and Freddie type documents, include a 30-day provision instead of a 20-day provision. And so now that simply delays you by 10 days before you can move to the next phase of foreclosure. So it's important to know the rules and regulations of your state for wraparound lending, for foreclosure, to negotiate the terms with your borrower appropriately. Include those in your contract so that when the closing agent is helping you draft these appropriately, that they're done the way you want them done. So if you found this video helpful and you're looking to expand your real estate investing career, head over to our website at theownerfinancenetwork.com, where you can check out our many owner finance programs that go in depth all about owner financing and the various strategies that they incorporate. If you guys like this video, take a moment to like us and leave a comment below on other videos you'd like to hear us produce. We'll see y'all next time.